All right, hello everyone. Welcome to this special discussion with the Commoner Law Group. Tonight we're going to be taking a look at the recent court order from a Central Florida federal court that struck down a CDC transportation mask mandate. You know, medical freedom in our country is definitely hanging by a thread these days. But, you know, recent federal court rulings have stopped the US government in terms of its overreach. The CDC, which operates under the Department of Health and Human Services, but the federal government is definitely being put in its place by courts in terms of their overreach. So just last week, in fact, this federal court in Florida determined that this mandate was struck down not only because it was an example of overreach, that is, it acted without the authority given to it by the legislature, but it also didn't follow the rules that needed to be followed according to more federal legislation in order to be able to make such mandates. So 2 days later, the federal government said that they would be appealing this decision, so it's not over. But tonight we're going to take a deep look into this case. And we're so lucky to have with us constitutional law professor Deana Pollard Sachs, who's going to help us tease out the finer details in this order by the judge. We all know that the narrative around mask mandates is a hoax. We all know that the narrative is failing amongst the general populace as well. More and more people are starting to wake up, or they're maybe just sick and tired of it. But really, the most important question facing the future of this republic, we the people, the question is, will we learn our lesson? So as long as we depend on the current legal system, we the people will always be at the effect of this tyranny in our government. Because we know ourselves to be the divine sovereigns, that we are the sovereigns of this land, and we individually are sovereign. And we don't need a federal judge to tell us that a mask mandate is illegal. We have already known that this kind of behavior, this kind of law enforcement, so to speak, or police action by the Centers for Disease Control and many other government agencies and the corporations and other entities that enforce these unlawful mandates, we already know that they don't apply to us, and that we never did respect them, and we never did give our consent. And as long as we the people live in a government by consent, we don't need to recognize these mandates. But tonight we're going to go through the dirty details anyway of the two major statutes, the two major federal statutes involved in this court case, and the order itself that the judge very precisely defined all of the various terms and statutes that apply in coming to her decision. We're going to go through them, not so much so as to teach you how to be a civil lawyer yourself. That's not our job here at the Commoner Law Group. We are here as an educational outfit to empower the average person to know the principles and practices of law sufficient to be able to handle your own legal affairs. So the intention tonight is to teach you how to become more attuned to exactly how bad it has gotten, how much our government and the court system and the legal system in general are designed to keep us subordinate, to treat us as subjects. And we're going to see, not only from the order, although the order was perceived by many people as a victory, we're going to see that on one level, the kinds of things that this court believed needed to be proven in order to take away this mask mandate. And you're also going to learn some of the defenses that the federal government used in continuing to try to keep its mandate in place. And that's not good news either, because if this is really what the government thinks about us, it's not a good thing. So I'm just going to go ahead and right now introduce Deana Pollard Sachs and have her say hi, and then we're just going to jump into this. I'm going to do a quick overview of the order so that we can get everyone sort of level set real quick about the case itself. And then yeah, Deana and I and the rest of you will be able to have a good discussion about it. We're going to basically focus on the 4 counts and the plaintiff's arguments, but the defenses as well. And again, what it says about the nature of law for you and me, the free sovereigns of this land. Then we'll take your questions and comments as well. Deana, thanks for being here. I know you've been burning the candle at both ends. Is that a good way to say it?
Yeah, and traveling, tired, yeah, but really happy about the opinion.
Yeah. So great to see you. You look great. You're one of the most high energy people I know, which I love, which tells me so much. And it's natural energy. It's natural, God-given energy that you have. You operate in a very high vibration. I guess the hazard is that you take on too much, like I do sometimes. Yeah. But anyway, so thanks for taking out the time. I know for you, you could do this with 2 hands tied behind your back, so it's not going to be hard. Not going to be hard. So yeah, let's go ahead and take a look at this order to start with. It was some 50 pages. It's a good read, again, from the point of view of understanding exactly what kind of things go on in these courtrooms.
Well, Clint, I think it might really help for me to create a context within which to explain how this happened, because we've seen a lot of cases challenging vaccine mandates and mask mandates in the past year or so. And the cases generally have not had a lot of success. And we've talked about this before about the lawyers making a lot of mistakes and just bad arguments and these kinds of things, filing things late. I mean, things it's just embarrassing for our side of this. However, the one area of law that is working is called basically the non-delegation doctrine. But the non-delegation doctrine is a general term. What it means is that we elect people to make policy for us. Those people are called legislators or congressmen and congresswomen. They are directly responsible to us. If they don't do the right thing, we can vote them out. It's called representative government. It's called a democracy. What's been happening is with the mask mandates and the vaccine mandates, because they are so political and so controversial, our legislators are not passing mandates. They're leaving it to lower unelected people, college administrators, administrative agencies, regulators, people who aren't accountable to us. And they're doing that because they don't want to be voted out of office next election. So what's happening is a lot of these people who do not have the authority to pass laws are passing health policy laws, requiring vaccines, requiring masks, and that sort of thing. They're all known as ultra virus acts, meaning they're outside of the authority or outside of the jurisdiction of the person or agency making them. So when you look back to OSHA and how the court struck down OSHA, I told a bunch of colleagues a long time ago that they're so out of line trying to pass a vaccine mandate. That was my opinion. And then the court did come down and say, basically, yes, they were out of line because of the non-delegation doctrine, meaning that although legislators can delegate to some degree, one thing is the delegation has to be very, very clear and specific. Whether it's Congress or state legislature, they have to be very specific in their delegations so that we know that the agency that is often unelected, like OSHA and like these other agencies, are actually given the authority by Congress or by the legislature. So the first step is, did they actually get the authority? That answer was no in OSHA. But let's just say they did have the authority. Now they're going to talk about the vaccine mandate for the healthcare workers. In that case, 5 justices said they did have specific enough delegated authority to pass the mandate as the healthcare workers. That's why the 2 cases before the Supreme Court went in different directions. And Kavanaugh switched sides. Well, actually, the OSHA one was 6-3, but on the 5-4, Kavanaugh sided with the majority saying it was constitutional. Now, the 4 that said it was not constitutional were questioning the second layer, the question of even if they did get delegated authority, even if the authority was specific enough, could they do that? And the 4 said, no, this is not something the federal government can do or any of its agencies. So in this case, what we're looking at is a regulatory agency trying to pass a mask mandate. And all of these come down to the first step, again, is statutory interpretation. The first step is, did the rulemaking body, the elected body, give specific enough delegated authority to this agency, regulator, or school board to create a vaccine or mask mandate? If that answer is yes, the second layer is, can they do that? And so in this situation, there was a lot of statutory interpretation to see whether or not the delegated authority was broad enough to cover this kind of mandate, and this court said no. So the court had to look at the language used in the delegation of authority, and there's a lot of pages on that. It's really specific with, you know, dictionary definitions and all that. But I just want to contextualize that for the listeners so they know that this is yet another ultra-virus case. This is a case that stops at the first layer and says they didn't have the authority. Does that make sense?
Yes, thank you very much. And the two statutes that we're going to take a look at briefly are the Public Health Safety Act and the Administrative Procedures Act. And both those were passed many years ago. So as far as I know, there's no legislation recently, even in the COVID era at the federal level, that would say the CDC or any other federal agency has some authority that they didn't already have before pre-pandemic. Is that right?
Well, I mean, this is what's so crazy about all of this is that the people pushing the vaccine mandates, largely the Democratic Party, largely Big Pharma, largely the technocrats, these people who are in bed together, all of them controlling our mass media, the pharmaceutical industry, politics on the left side, they all want to push the vaccines, but notice that our people, our elected people, they don't want to do it. They don't want to lose their position as an elected official. So you're seeing our cowardly legislators, federal and state, kind of, you know, taking the hands-off position and letting these school boards and college administrators and these other agencies just create these mandates, which then are challenged because they don't have the authority, or because even if they had it, it's not constitutional to delegate too much. They can only delegate so much, because remember, they're supposed to be representing us. And if they delegate authority, where's the responsibility? Where's the consequences? Where's the accountability? So when you start delegating authority to people who can't be voted out of office, you've got a problem, because we've lost democracy. So yes, most of these laws they're trying to use were not created just for COVID. Again, because our legislators aren't going to do that. They don't want the public to be as angry as the public would be if they're doing it. So these wayward, you know, secondary people, they're not elected, they're not accountable, they're grabbing anything they can grab onto to try to say, oh, we have authority, here it is, in this new context with COVID. Now, one of the things that the Fifth Circuit said that I thought was so funny, the Fifth Circuit wrote a very, I think, comical opinion when on the OSHA mandate. It was the first court to strike down the mandate. Actually, I'm not sure if the trial court did, but the Sixth then reversed it in this unusual proceeding. Then the U.S. Supreme Court went back to the Fifth Circuit's decision, and the Fifth Circuit was saying, you know, these people are grasping at straws, like looking for a statute, you know, digging through, you know, a haystack, looking for a hook to be able to do this and create this vaccine mandate. And the Fifth Circuit kind of laughed about it in a sense, the way, if you read the opinion, the way they said it. So yeah, they're grasping at straws. They're looking for any statute they can contort or misconstrue or, you know, distort in some way to say, oh, we can do this, when actually, no, you can't. So again, the healthcare worker mandate's different. And one of the things Justice Thomas said that's really, really important to understand is the issue of the efficacy and safety of the vaccine was not before the court. What was before the court is whether or not the healthcare worker vaccine mandate was ultra virus or not. The court said in a 5-4 hotly disputed decision that it was not. However, keep in mind, no one raised the Liberty Clause challenge. No one looked at the medical evidence. No one even looked at whether or not this vaccine mandate was safe or possibly could withstand a constitutional challenge based on medical safety and efficacy. Liberty Clause challenge, that would be your original 1905 case, Jacobson versus Massachusetts, where the court looked at the medical evidence and the safety and efficacy of the vaccine, which had been around for 100 years, and which was very effective according to studies from all over the world for 100 years, and which was attacking a disease killing hundreds of millions of people called smallpox. Keep in mind also in that case, the statute had an alternative to not take the vaccine and to pay $5. So that's the case people are relying on, but the reality is that that case does not help Big Pharma. It doesn't help the people pushing the vaccines, in my mind, because once this court looks at the medical evidence and the burdens on, I believe the burdens on the government, because it's a medical mandate. And my article is coming out any day now in Florida State University Law Review, is a lead article called Judicial Protection of Medical Liberty, discussing how the court has treated all medical liberty cases with a very high level of scrutiny, meaning the government has the burden of proof. So from whether it's an abortion issue or someone doesn't want to be sterilized or something like that, however you want to frame it, all the medical cases give a lot of deference to individual liberty because it's our bodies. Our bodies are protected more than anything. That's why when you look at the right to life itself, you look at capital punishment, you're going to get the highest level of procedure and substantive protection because you're talking about your life. So your body making choices about your health is a very close second, in my opinion, whereas property rights and those kinds of things are kind of a distant third. So that's my view on it, is any kind of medical liberty deserves a high level of judicial scrutiny. And Justice Thomas was the one who said at the end of that decision, we didn't look at that because it wasn't before us. So just because they won in the healthcare vaccine worker mandate case doesn't mean that same mandate couldn't be challenged again on liberty grounds as a liberty clause challenge. And again, that's what my article coming out is about. So the cases we're talking about are all concerning structure, whether the rulemaking body has authority to make the rule or not, the mandate, whether it's vaccine or mask or whatever.
Thank you very much. Yes, in fact, I'm just going to go ahead and recommend people watch your presentation on the liberty question, the liberty clause approach that was so very fascinating on YouTube.
Oh yeah, but I also have a weekly show on Revolution Radio from 6 to 7 p.m. New York time, 3 to 4 p.m. California time, every Saturday. Revolution Radio on Studio B, and my podcasts are on Rumble. The channel is Counter Speech. If you go to Rumble and choose the channel search and just search for Counter Speech, I have a bunch of videos on there. And Reiner Fulmick was my first guest, which is why YouTube kicked me off within like a few hours. So I moved to Rumble.
This video we did together in December.
Oh yeah, I remember.
The Liberty Clause. And just so everyone knows that the Liberty Clause has not really been tested yet. She and I have been talking about how we can popularize this. If anybody watches this video and wants to participate in a court case where we can bring forth the Liberty Clause, please contact me at info@commonerlaw.com. Could you just go ahead, can you maybe specify some of the elements a person would have to be a plaintiff?
Sure. Yeah, standing's been an issue in some of these cases because we have public interest groups bringing cases, and you have to have a live case in controversy in federal court. And you're going to bring this in federal court because it's a constitutional issue, meaning you have original jurisdiction in federal court. If you don't bring it in federal court, the government will probably remove the case to federal court anyways. And in my opinion, you want to be in federal court. Federal courts are trained on constitutional law. In fact, Erwin Chemerinsky, my former professor and friend, used to go every year to Philadelphia and train all the new appointed federal judges about the Constitution, because they have to deal with it all the time in their courtrooms. But anyway, if someone wants to reach me, you can go to counterspeechusa@gmail.com. counterspeechusa@gmail.com is my counterspeech email address if you have questions. But yeah, you have to be a person who was injured in some way. Now, when it comes to a vaccine mandate, there's a couple of different things going on. For example, in this case, and by the way, I know Leslie Manookian, who's the founder of Health Freedom Defense Fund, and they were able to get standing because they have this organization with people in all 50 states, but at least one person in the organization has to be subject to the mask mandate in order for them to have standing. Anyone who's subject to it as a matter of either employment, or they're in school and they're told you have to take a vaccine or you have to leave our university, those people all have standing. Because, for example, I have a client on the East Coast. She works at a university, or she worked at a university, and they passed this vaccine mandate. Again, college administrators just pass a vaccine mandate, in fact, with no delegated authority, not even ostensible authority. So I'm pretty excited to get moving on that case because they have nothing to grasp, in my opinion. We've looked through the law, we don't see anything. In fact, they actually said they're relying on the CDC website. Okay, that is not delegated authority. Okay, going online and researching is not delegated authority. Delegated authority can only come from the legislature through official legislative action. Anyway, so she was fired for not getting the vaccine. Now she has standing. She lost a job because she didn't get a vaccine, which we believe was an unconstitutional mandate. So basically, you have to have a live case of controversy. It has to be ripe. It can't be something that might happen. Like, for example, if my client in the East Coast wanted to sue because the university said that in 3 or 4 months, we're going to pass a vaccine mandate. And if you don't get that vaccine, you're going to be fired. Okay, it wouldn't be right for review until she lost her job, because even
Okay,
because they
well,
can change
we
their
know,
mind.
we have lots of people who work both for governments and for the private sector and the military as well. So are all those people candidates for the Liberty Clause as individuals?
Well, anyone in the military, anyone in a public employment position, yes. Anyone in a private employment position, no. Walmart, Walgreens, Kmart, all those, Nordstrom, no, because the Constitution does not apply. It's called the state action doctrine, and you have to find state action for the Constitution to apply. That's really frustrating for me because I'm seeing these, pharmaceutical companies or pharmaceutical outlets, Walgreens, Walmart, CVS, places like that, really getting oppressive with their employees and really coercing them to take vaccine that they don't want to take, or maybe granting them begrudgingly, an exemption, and then treating them badly at work, and making them put on all kinds of, different colored masks or something to show they're not vaccinated, to embarrass them at work and to have the customers kind of run away from them because people don't know
Yeah,
what's going on.
that's the worst.
But yeah,
Getting fired is pretty bad, but then the humiliation on top of that. So, so even though it's a private corporation, a corporation is a creature of the state because you have to be incorporated by a state.
right.
Does that not extend? That isn't.
No.
Okay,
no.
could you say the name of that doctrine again, please?
State action doctrine. It's called the state action doctrine. It's a term of art, and it means that in order for the Constitution to apply, it has to be the government taking the action. And when the government is entangled in some way, the answer is no. If the government is in some way sort of controlling the private entity, the answer is usually no. The government, let me give you an example. I was talking to Erwin Chemerinsky about this, and Erwin is the dean at UC Berkeley School of Law. He also writes the most popular constitutional law textbook in the country. So he's a great source. And I said, and we're talking, going back and forth, and I'm arguing that some of these entities should be deemed the government for purposes of, like, for example, Facebook, for purposes of the First Amendment. They've taken over sidewalk picketing. They are essentially the way people communicate political views. And so to me, to say, well, it's private, you can't regulate them, but yet they're regulating speech, they're controlling speech, I think that's a close call. But in general, we finally agreed that I said, well, Erwin, what if the FBI hires a private investigator and says, I want you to go out and hang out by Sam Smith's house, take photos of Sam Smith, working in his yard, and then bring it back to the FBI force. Now you have state action. You have a private individual being hired by the government to perform a task for the government. But anything short of that, it's very, very hard.
Okay. So corporations say, for example, they say we have to do this because of the state mandate. We have to do this. That's what they tell their employees, these private companies. They don't say that we're doing this because we think it's the best thing to do and we're doing it independently of government. We're doing it because the government says we have to.
Well, and I mean, now you have sort of a possible argument they're the arm of the state, aiding and abetting the state or something like that. And there have been cases where a private individual has been found to aid and abet the government, and therefore that private individual's behavior is subject to Section 1983 liability. And to back up, Section 1983 is 42 United States Code, Section 1983. It is the vehicle to bring a constitutional claim to court. Although some claims can be brought directly, but it's the one that most use. And the reason why is Congress created this vehicle so that when you need to bring a civil rights action, you bring it in court, and your constitutional violations are your predicate violations. You need predicate violations, but this is like the vehicle. It's like the bus you jump in to get to court with your constitutional claims. And the beauty is Section 1988 gives attorney's fees. So that's the real reason people use Section 1983 most of the time. But the problem is, again, there's a lot of stuff the government does. They're entangled. They give you licenses. They control you through regulatory action and things like that. And you might argue, well, they should, these private companies should be considered the government because they've got this, the government's controlling them. But the answer is usually no, because if every private entity was deemed to be a government entity for purposes of constitutional liability, gosh, it's almost everyone. I mean, we all have our bar licenses from the state. That's on enough, obviously, but I'm saying the state and the federal governments regulate so much that unless you have a hard line that the actor has to be an agent of the state, an employee of the state, a principal of a public school, a military sergeant, it's really hard to get state action. It can be done, very rare.
Yeah, I understand. Thank you very much for that elucidation. I mean, as a common law advocate, as a free sovereign, of course, on this land, we don't stand for anyone infringing on anyone's natural rights ever, no matter what statutory rules or or doctrines say, you know.
And I agree
That's
with that. You're talking now about the Ninth Amendment. You're talking about the way that the Constitution was set up. And the Constitution wanted a limited federal government because the crown was the concern. The kind of power the king had, the kind of power royal people have in England. We got away from that. We didn't want that. We want more individual liberty. So they created this limited federal government where the Congress's powers are limited to certain categories in the Constitution. Everything else goes to the state governments or the people. The Ninth Amendment says everything not enumerated that belongs to the federal government stays with the people. The 10th Amendment says those unenumerated powers are reserved to the states. But now you have an issue, but what about 9th versus 10th? Where do you draw the line there? That's a big question. There's not a lot of jurisprudence on the 9th Amendment, but your group is basically advocating for the 9th Amendment, saying we the people have the powers under the Constitution that aren't given to our federal government. And we need to exercise those powers because right now, the state governments are also infringing on us. And that's the 10th Amendment when they're saying, well, we get all these powers. We have all the non-delegated powers. Okay, great. But don't forget about the 9th Amendment. The 9th Amendment says the people retain those powers.
exactly. That's the 9th Amendment is my favorite amendment for that reason. But even before the 9th Amendment was ever written, before the Constitution was ever even dreamt of, there was something called common law, which protects our rights. So
and natural law was
that's where we stand.
Biblical time, yeah, definitely.
Okay, good. So before we spend all of our energy on the finer notes, this is a great conversation. I love it. We're going to get into this court case because I know that's why people showed up, and I just want to basically review the first and foremost the various counts that were the plaintiffs brought forth. So here we go. Plaintiffs' amended complaint challenged CDC's mask mandate on several grounds. First, it alleges that the mandate exceeds the CDC's statutory authority. In the alternative, it alleges that if the mandate is statutorily authorized, Congress improperly delegated its legislative power to the CDC. The amended complaint further alleges that the CDC improperly invoked the good cause exemption to avoid the notice and comment procedures required under the APA. And finally, it alleges that the mandate violates the APA because it is arbitrary and capricious. So the statutes in play here are this APA, which is the Administrative Procedures Act, and that was passed quite a few years ago. That basically enumerates a whole bunch of rules that any administrative body, any executive branch administrative body agency has to follow. And yes, this court ruled that indeed the CDC just broke those rules, skipped the rules, tried to find loopholes that weren't appropriate. And I think that's really one of the biggest lessons we've learned already tonight, Deana, that you brought forth, the fact that these millions and millions of statutes and codes and rules and regulations and mandates and orders and on and on and on really are produce a breeding ground for tyrants to go find and tease out any kind of line in some volume somewhere that they think would give them the power. And that's what the CDC in a way has done here. At least that's what it shows them arguing in this case.
Mm-hmm. Well, I mean, our laws are not drafted the way I would draft laws. I would draft them more simply. I would draft them in a way that anyone can read them. Any smart fifth grader would understand what the laws said. In fact, I did draft all the model legislation for Naomi Wolf on the vaccine mandates and how to prevent making them illegal, for example, requiring schools to stay open. If you ever go to dailyclout.io, it's all listed there. And I guess 26 states have already adopted some of that legislation, but look how easy it is to read. Look how simple it is. That's what should be done, but that's not what's done. What's done is our Congress and state legislators make very convoluted, difficult to read laws. In my opinion, is partly just a lack of talent. The other thing is they want to keep people in the dark. So what that creates is a huge body of law with all sorts of phrases and clauses where people aren't really sure what they mean. So in a situation like this, when some really smart people want to find a way to exercise powers they don't have, they're going to peruse those laws and look for a clause and look for a term, look for something they can say, oh, that gives us the power. It doesn't, but they've said that. And so that's what they're doing. They're just, like you said, teasing out all this language, finding anything to grab onto to say, look, we have power. And then they pass a mandate and they look to that little piece of legislation, that little clause, and say, here's where it derives from.
That's right. That's right. So here we're looking at the very this singular section out of a huge volume of an act called the Public Safety Health Act. And this is the regulations to control communicable diseases. And so this is what they were using. This is what the CDC was using as authorization, in particular sanitation. The ability to, this is what the whole sanitation was, whoops, what did I just do? I hope I didn't lose that now, because this is, look how many, this is how big this legislation is.
That's what I'm, it's just, to me, it's absolutely ridiculous. This, well, I think our legislation should be much more straightforward, simple terms. The people should be able to understand it. Yeah, well, what they did is they tried to say that sanitation meant you can force people to keep germs to themselves. Okay, and before I go into some detail with, well, what does sanitation really mean? Does it mean cleaning something, sanitizing like it sounds, or does it mean forcing people to keep germs themselves by wearing masks? And as we know, the court settled on the former definition by going through the history of the meaning of the word when the law was passed, and said, look, sanitation then meant what it pretty much means now, and that is cleaning, not telling people you must wear a mask, keep your germs to yourself. That's not cleaning.
Yeah, I mean, the order itself had to spend at least a couple paragraphs just establishing the notion that when we're interpreting the law, we need to use the common sense or ordinary sense of the word that is there. So, I mean, that itself wasn't even, wasn't even, you couldn't even assume that in a world of justice, where justice is being served, that we can just automatically assume that the words that are written are the words that you would understand them to mean. But they had to, of course, the judge had to actually establish that in her order as well, when she went on to say, and sanitation does mean this, this, and that. Right. So here we are again, the regulations to control communicable diseases, and it is not only to say sanitation and other. It says here sanitation and other means. Where is it? Examination, transmissions. Where and others, and they even had to argue that and others. The CDC was like, well, it said and others, so we can, it's like we get a blank check and do whatever we want because it says and other things. So the judge had to.
What they meant though was, well, I mean, the second sentence says it informs the grant of authority by illustrating the kinds of measures that could be necessary: inspection, fumigation, disinfection, sanitation, pest extermination, and destruction of contaminated animals and articles. And this is what the court is saying on page 11 of the decision. What the court's saying is that, look, if you look at what those things really are aimed at, maybe it's not all exclusive, but it gives a genre of power that it is exemplified by fumigation, extermination, pest control. Okay, and the question is, does forcing people to wear a mask fall within that group or that genre of powers or not? Government saying, yes, sanitation means making people keep their germs to themselves. And the challengers are like, no, it means cleaning, fumigating, destructing contaminated things. And as we know, the challengers won that argument in terms of interpreting what sanitation meant.
Very good. Yeah. And it's excruciating to see how sanitation, pest control, here it is right here, inspection, fumigation, disinfection, sanitation, and
but they actually let me just, it's painful.
And other measures,
right,
as judgment may be necessary. And
that's technically what the government said, that they were relying on that open clause. But again, that whole clause, the open and other measures, here's what it said. A requirement that individual travelers wear a mask is not inspection, fumigation, disinfection, destruction, or pest extermination, and the government does not contend otherwise. Instead, it argues that the mask mandate is a sanitation measure or an other measure akin to sanitation. So they're using that other measure, but to try to say that, and this whole opinion is painful to read, I might add. It's so long and so just tedious. But again, the court is saying, look at the group of things they're talking about. Look at the kinds of action they're authorizing. Pest control, sanitation. You really can't say with a straight face that making people wear a mask to travel is sanitation, but yet the government did. And we're seeing that more and more, the government making ridiculous arguments. I just went through a trial where I couldn't believe the behavior of the Assistant Attorney General of Texas. I mean, this person did things that he knew were wrong, pushing to get evidence in that was clearly inadmissible evidence, that kind of thing. So it's really scary to see how our government is no longer helping us at all, not even going, not even really abiding by clear law, making ridiculous arguments in court that I never saw governments make those kind of arguments until pretty recently, although I'm not really an expert in this either. So, but it's really kind of scary that our government is our enemy. The government attorneys are making, in my opinion, ridiculous arguments, a total stretch of the law, a stretch of common sense, a stretch of common meaning of words, because they're so determined to control us in a way that is not constitutionally permissible. So they're just like out on a limb there, just, screaming and yelling, hey, this is the law, when no, it really isn't. Thankfully, this judge saw through it and took a lot of time to create this opinion so that she would probably be upheld on appeal.
Yeah, it is. It's tough. But the judge did also say here, I'm trying to find the line. She said, if we allow the CDC's interpretation of other measures, well, it could include anything. She said, why not? I forget what example she gave right now, but it would be, it would allow the CDC to order, any kind of thing you can imagine, vitamin supplementation and just
Right.
any old kind of thing. So yeah, that was excruciating for sure. But look at this, now let's take a look at this other statute that's at play. So the Administrative Procedure Act. It alone sounds horrific just by the name of it. I don't know how, in a way it sounds innocent. I mean, innocuous, but to me, if you think in an Orwellian sense, it's like, okay, when you know that the administrative agencies are the ones that are trying to control us, it's they who are overstepping their bounds. It's all the administrative, bureaucratic agencies. So it says agency means each authority, whether or not within the subject to review of another agency of the government of the United States, other than Congress, the courts, and the governments of the possessions, territories, and the District of Columbia. So right. It's these entities that claim authority over our lives, and unfortunately, the founders of our great Constitution, our great government, wanted to have checks and balances, but I think it's pretty clear, I don't know what you would say, Deana, that the separation of the branches, for checks and balances is pretty much dead and gone.
Yeah, it is dead and gone. The problem is we have so many horrible people in politics. They are not very smart as a whole. And there's some exceptions. Ted Cruz is supposed to be extremely smart. But Ted Cruz ignored a very detailed letter I wrote him about sexual assault going on in a law school that I worked for and all the things that have been happening to the women there. And I asked him to do something about it, and he didn't respond to me at all. So he is very smart, but even the really smart ones don't always take seriously the very serious problems of their constituents. The bigger problem, in my opinion, is just the complete lack of talent among our elected officials. They're not very smart. I mean, look at Joe Biden trying to talk. Look at him trying to speak. And this is an embarrassment for our country. There's no way someone like him should ever represent our country. We should have really smart people representing us who can speak well, articulate, who we are as a people, and most importantly, uphold the will of the people. So what we have is a lot of collusion, a lot of just way too much wealth concentration with people who have a lot of money being able to throw the election one way or the other, because we all know from many years of study that the person who spends the most on an election usually wins. And that's just a fact, because the way they can influence the voters through conscious and unconscious, messages through the media, through social media. So we have this incredible wealth concentration. And those people have enormous amounts of money in the line, depending on what the law says. So if a law can force a vaccine mandate and those people own a lot of interest in the vaccine manufacturers and will get the benefit of those vaccine mandates in terms of huge profits, people like Bill Gates, then we've got a problem, because the same person who has so much money can help get people into office who will then vote his way to pass laws to make his products required by our people. And just a reminder for those who aren't really familiar with it, communism is when the government owns all industry. So you don't have private industry, meaning the government can pass a law to make you buy a product, and they're the ones profiting from the product. It's a terrible, terrible system of government. Communism is extremely dangerous. People are extremely unhappy in communist regimes, but they often get people to go along with it through socialist concepts such as free education, free healthcare, free this, free that. And a lot of people are like, oh, that sounds good to me. Yeah, until there's a complete merger of all of our systems, all of our manufacturing industries and government, and then it's full oppression. So anyway,
you got, well, for sure, and all that money that has to come from somewhere. So of course, another communist tenet is to be able to control the printing of the money, which they've been doing for over 100 years now.
It's terrible, terrible form of government. Communist regimes normally fall eventually. People are miserable, very high suicide rates in certain areas. I know, the more oppressed a community is, a country is, the more problems you have with all kinds of abuse, not just people abusing other people, which does happen because when the government oppresses the people oppress each other, but also drug abuse, substance abuse, alcoholism, things like that. There was an area in Russia that had the highest suicide and alcoholism rates in the whole world for a while. I think it was called the Black Lake area or something. I don't even know if it's true anymore. It's a long time ago, I did this research, but I was thinking to myself, well, gosh, if I lived there in that kind of regime, I'd probably want to commit suicide too. I mean, yeah. People have to be free. Look what animals will do in the wild to seek freedom. I mean, they will die over their desire to be free, just like we will do. A lot of us will do. And those who don't probably wish they would have. So it's too much concentration of power, too much concentration of money. How do we reverse it? I mean, that's what my show is about in Counter Speech. What do we do? How do we take back our democracy? And the first thing I would say to people, the number one fastest shortcut to stopping what's going on is stop buying prescription medications. Stop to the extent you can. Most of us don't need most of what we're given. We are feeding the monster. Every time you buy a prescription medication, you are feeding Big Pharma. You are creating this enormous profit margin they have. So we need to stop taking prescriptions, find alternative remedies, find natural solutions. And of course, I'm not a doctor, so I'm just saying this is something we need to do. But the average American takes 11 prescription medications per year. 11 on average for Americans ages 12 through 80 or something like that. I don't know if I got the age right, but I know I got the number right, 11. So for every person who doesn't take any or takes 1 or 2 a year, you've got someone else taking 20 a year. And some of these prescriptions are very, very, very expensive. Always ask for generics. If you have to take a medication, always seek generics. You are taking the wind out of Big Pharma's sail. We want to stop that enormous profit margin. And the way we do it, stop buying prescriptions to the extent we can. Question your doctor. Ask if there's alternatives. Always ask for generic medication. So that would be my first step, is to stop feeding that Big Pharma monster.
Absolutely. Okay, so what we're going to do is we're just going to review the final conclusion by the judge. And if you want to learn more about the Liberty Clause, I know some people in the comments are asking about it. You can watch the video on our YouTube channel about that. We sort of round this out, and then we're going to take some comments and questions from folks who took their time out to be with us live tonight. This was going to be recorded and available as well on our YouTube channel coming up soon. So let's
just real quickly, Clint, very quickly, for those who want to read all about medical liberty under the Liberty Clause, the article is called Judicial Protection of Medical Liberty. It's been online for, over a year now. So even though it's not published in the Florida State University Law Review yet, it is available online. Just Google Judicial Protection of Medical Liberty. It'll come right up and you can read it if you want.
Yes, it's a fantastic article. Everyone get that. The link is, it's also in the, I believe that link is in our YouTube video. But yeah, so let's just take a peek here. I'll read it real quickly. Conclusion: it is indisputable that the public has a strong interest in combating the spread of COVID-19. In pursuit of that end, the CDC issued the mask mandate, but the mandate exceeded the CDC's statutory authority. improperly invoked the good cause exemption to notice and comment rulemaking, and failed to adequately explain its decisions. Because, quote, our system does not permit agencies to act unlawfully, even in pursuit of desirable ends, the court declares unlawful and vacates the mask mandate.
Good. And let me explain very quickly what that good cause exception was and why they failed at that. The good cause exception is kind of like declaring an emergency, a state of emergency. So what that does is allows legislative bodies to bypass normal procedures. It allows regulatory agencies to bypass normal procedures, which is why declaring a state of emergency is so dangerous in terms of people's rights. And Naomi Wolf, in her book called The End of America, published in 2007, discusses that this is one of the 10 ingredients to every fascist takeover. They always declare a state of emergency because they always want to bypass procedures to give notice to the public and let the public comment and object to the passage of whatever they're trying to do. In this case, there was a good cause exception to the notice and hearing requirement to pass these kinds of mandates. And this lazy body didn't even really bother trying to say why there was good cause. They just had some conclusory sentence saying, well, we have good cause. Okay, well, that's not good cause. You can't say you have good cause. They have to prove good cause, and they failed to prove good cause. This thing was passed, gosh, over a year after the COVID-19 came out. Where was the pressing emergency back then? Why did it take so long for Biden to try to force it down people's throats? So this court was sort of saying, you guys, once again, you're claiming good cause, but where's the good cause and why the delay? And if it's such good cause, the court noted, why aren't you talking about the efficacy of the masks? Because some work better than others. And by the way, why are you exempting 2-year-olds? Who says a 2-year-old can't transmit COVID, whereas an 8-year-old can? So the court kind of was all over their case. And I like what the court did here because she had a lot of common sense, just saying it like it is. And I'm really happy with the opinion.
Yes, thanks for emphasizing that. The government was it's just miserable. My expectation of government performance isn't that high anyway. And here we have it.
Government lawyers aren't even creative. They're not even that good. And the only reason they're winning, in my opinion, in any of these cases, is that they're still better than the plaintiff's lawyers. Because the plaintiff's lawyers have such less resources. The government attorneys have unlimited funds, unlimited clerks, unlimited people to help them, to write for them, to share briefs. Remember, a lot of the governments are doing this. They're sharing all over the country their research and their work. Whereas we as plaintiffs lawyers, we have to invent the wheel sometimes, although we are starting to combine forces. And I have to tell you, Bobby Kennedy Jr., Robert F. Kennedy Jr. is one of the reasons why he has connected a lot of us. He connected me to Leslie Manookian, who started this organization, who won this case. He connected me to Reiner Fulmick, and I know Reiner now. Bobby Kennedy Jr. has been a magnet for people who care about this. And I can't explain again why some of the attorneys associated with his organization have been so lame. But I think they're volunteers and they're overworked or whatever. But this is the thing I keep telling people like him and others who have enormous donations. You've got to hire top-notch lawyers. You can't go up against the government attorneys without having those kinds of lawyers, top of their class from top law schools with backgrounds in constitutional law. And that's not what's being hired. Now, Leslie Manookian's group with this Health Freedom Defense Fund, they managed to get a great order, and they managed to find people who knew how to argue these cases. But again, we're connecting now, which is what we need. We need the plaintiff side, our side, the people's side to connect the way the government has always been connected. And that's one of the things that's been happening through Children's Health Defense and other organizations. So we all kind of know each other now, which is really good. We can help each other.
Very good. In fact, so as we go to questions, I have a question though. It's kind of what you were talking about. I mean, this transportation mask mandate has been in effect for 20 months. And my question is, it was obvious to me that it was wrong, as I was saying earlier, just because it's common sense wrong in so many ways. You don't need a judge to tell you that. But why did it take 20 months for this finally to happen?
Well, it's part of the case and controversy problem is that until something goes into effect, you can't challenge it. Once you challenge it, you can file a petition for an injunction called a temporary restraining order or preliminary injunction that halts the enforcement of the mandate pending an outcome. Sometimes, they're one and sometimes they're not. I can tell you one that was lost in LA was lost because the lawyer, a rather young lawyer, in my opinion, Nicole Pearson, she filed 500 and something pages of documents late. You can't do that. Can't be late ever in any court. This is state court. So, it takes time, but if you mess up on the preliminary injunction stage, now you're going all the way to trial. It's going to take a couple of years. Now, these guys, I think, won on the preliminary injunction. This was a preliminary injunction, which is good, but that takes time too. Because what happens is, you file for it, and the other side gets whatever, 30 days or whatever it is to respond. Then the court responds whenever the court responds. One of the things I like about California is the California courts are bound by certain time limits. Like if they don't respond to a motion for summary judgment within like 45 days, it's deemed denied. Whereas in Texas, they can sit on it for 2 years. It's really offensive to me that a Texas court can do that, but they do. So then between those two extremes, there's all kinds of rules. So what happens is in federal court, that one side can ask for extra time. Okay, now you've got another month delay. So the months can add up very quickly, just the normal process. And again, if you miss, if you swing and miss on the preliminary injunction stage, you're going all the way to the end. So 20 months, I mean, it sounds like a lot of time, but in a federal court, it's really not that much time. Oftentimes, motions to dismiss won't be heard until 20 months after the filing, or 10 months.
What we're dealing with here is again, these tyrannical government agencies who are acting without authority, promulgating any number of things that are obviously enforceable. I mean, I got kicked out of an Uber. I got kicked off of a city bus. I was threatened that the pilot was going to talk to me on a plane because I wouldn't wear a mask.
I'm sorry, this is motion for summary judgment. I'm sorry, this is cross motions for summary judgment. It wasn't a motion for preliminary injunction.
Okay.
So they won on that. So that explains it more. Summary judgments come after usually requests for preliminary.
All these procedures, I understand, and procedures, time. But isn't there anything that we the people have at our disposal to stop something that is so clearly beyond the authority granted to these agencies? I mean, before they've done all the damage, well, the damage is done and now it's too late.
Right. We can resist in solidarity like you have. But unfortunately, and one of the things Leslie said to me is she said, the standard is so hard for preliminary injunctions. I disagree. The same challenge that Children's Health Defense made in LA was made in San Diego, and the San Diego lawyer won it. The same law, the same body of law was involved because there was a delegated power from the California legislature to schools, but it was the same delegated authority. It was the same law, but it was deemed to be ultra virus in San Diego and not in LA. So the San Diego school children were safeguarded, but the LA children weren't, only because of the quality of the lawyers on the two cases. So it was exactly, they should have won that. They should have won that in LA. But anyway, your question was, why did it take so long? Well, I remember Leslie once telling me it's a little harder to get a preliminary injunction. I mean, you're talking about basically stopping a law from being enforced before the parties have had time to take discovery or fully flesh out all the issues. Now, the motion for summary judgment comes after discovery and after the parties have had a full opportunity to find out everything about the other side's case. So I think the summary judgment is also a very hard standard, but I think probably a little easier than preliminary injunctions. So that's why it takes longer. It's a different stage of the proceedings.
All right, I guess I'm just pissed. I'm very pissed. I don't know how to say it. There's got to be a way for we the people to act more quickly with these tyrants, because they know, again, it's like a thief. They come, they steal all your stuff, the damage is done. And by the time you go looking for them 20 months later, and I guess the other question is, can we hold them accountable? Are there damages? I mean, I want to be compensated for the heck I was put through.
Well,
they overreach. It's been determined. If it's held in appellate court, then we can say they did wrong. They disrupted the economy. There was some comment about the disruption to the economy in the court order.
Injury is a term of art. It doesn't necessarily mean you have a cut or a scrape or something like that, but you have to have some kind of harm or injury as a result. Now, the First Amendment body of law, I would say, is going to provide you with the best precedent. because the courts have said that if you are basically pushed off a sidewalk by a police officer and not allowed to speak or stand on a soapbox in the olden days and, you know, say your piece, the courts have said that being prevented from speaking just like that without any other injury is an injury. You've just been denied your First Amendment rights.
Exactly.
So yes, you can get to court and you can challenge state action quickly and without a lot of what you would call a lot of harm because your rights were violated. So that's a good body of law, but this isn't speech. You remember, speech is always protected higher than other rights. It seems like speech is like almost hands off. And the irony, of course, is now the government and Facebook are, you know, hand in hand. I don't know if but Adam Schiff and the group of physicians and surgeons who sued because of the way he basically instructed Facebook and others to what he said, prevent misinformation. But this big organization of physicians and surgeons who do research and produce research said basically they were only publishing one side of the vaccine controversy, the side supporting vaccines and vaccine mandates. And they just lost in the DC circuit. So I think they're going to go to the US Supreme Court now. But my point is that the First Amendment is supposed to be so fiercely protected. And yet look what's happening now, where they're allowing Facebook and these other groups to totally control the content, totally control the narrative, and not allow everyone to spek freely, which is what the First Amendment is all about, letting everyone speak and letting everyone else decide for themselves, as opposed to being manipulated through hearing one thing 99 times and hearing the opposite one time. Because we know from lots of studies on the human brain that the more times you hear something, the more likely you are to accept it, no matter what it is. You could be told women are inferior. You could be a woman and say, well, I don't agree with that. But once you hear it so many times and you're not hearing the opposing view, you will begin to adopt it. It's the way the brain was made to process information. It's just the way we're made.
Yes, it's a brave new world we're living in, and that's why I have a big question to all of my fellow Americans. You know, how do we, the people, establish our sovereignty, restore the republic in the 21st century? I'm not willing, like so many people, to say that the Constitution and the common law and our founding documents are old-fashioned and don't apply anymore because they're of a former era and they don't work today because for so many technological reasons that
It's
just
not
don't
the
vibe.
Constitution, it's the problem. I don't even think a lot of it's the laws. It's the failure to enforce them. It's the ridiculous interpretation of them sometimes. And it's the desire by these power-hungry people to do things they're not supposed to be doing. And again, grabbing at whatever they can get their hands on, trying to say, well, look, I have power through this clause. So the Constitution is a beautiful document. Those men sat down without air conditioning, you know, in Philadelphia in a basement. A lot of it was written in a basement. Well, anyway, these people worked very, very hard. And it is a wonderful document with tremendous care given to split up powers. The problem is anytime those powers get together and form alliances against the people, we're back to having a problem. So that's where we are. And that's why the people have to rise up and, you know, exert their own power under the 9th Amendment and the 10th Amendment. The 10th Amendment also mentions the people, by the way. So that's why your group is so important and so successful, I would say, because people know intuitively that we're supposed to have the power. This is a democracy, a representative government. Our government is our enemy at this point in time. Our government is, and so we go to the federal courts because they're the one place we're supposed to be able to get justice. They're not elected. They're in for life. And so they're supposed to support the little people over the government. And because they're not subject to being terminated, they're supposed to be able to do that. Well, I'm seeing a lot of federal courts really oppressing people and doing things they're not supposed to do. It's really scary out there to me. But you still have some good federal courts and you have this federal court. So it's, you know, we still have some, but the Constitution has been manipulated, and many of the major themes, the separation of powers, federalism is federal versus state power, this kind of vertical power. Separation of powers is, you know, the 3 branches of government, what I call more vertical. I'm sorry, horizontal power. Sorry, I'm tired. So we have these 2 things: federalism with this kind of power, federal and state, and then the separation of powers with the 3 branches. And you're seeing collusion on all fronts. So it's a problem. We need to find a way. And I think what needs to happen is we need to create a People's Party of America, a new party, because the Republicans and the Democrats are both very ineffective. And no matter which side is in power, it doesn't really matter. Our rights as individuals, as a people, are being thwarted by both sides, by both parties. If we could come together as a people and from a grassroots effort, choose our own people to be representatives. Like I said on another show, it may be the local mechanic. It may be somebody who's serviced our cars for 20, 30 years, and we all know him to be honest and decent and to make good on his work. It may be a local hairdresser. It may be someone with such a support system to the housewives in the area that she is trustworthy and kind, and she picks up your kids when you're in trouble. We need people who are like that. We need people who should be in power, not these, I don't know even what they are, these
monsters
who are in power.
Yeah, they're self-serving monsters.
And
Yeah,
even good people who get into Washington, D.C. get pulled toward the darkness. Washington, D.C. is dark. And the thing is, lots of power centers are very dark. And it's a lot easier to pull a person in the middle toward the darkness than it is to pull a person in the middle toward the light. And that's why any counselor will tell you, if your child is hanging out with a bad kid, get your child away from that kid. And if your child says, yeah, but I'm going to make him better, or I'm going to, bring him to Bible study with me, or whatever they might say, the realities are that most of the time, the bad kid influences the good kid more than the good kid influences the bad kid. And so I think the same is true in life itself. Pulling someone toward the light is a little harder. And so we have to stand our ground. And, going to Washington, a lot of people aren't that strong. They get in, they may have good intentions going in there, but when they get in there and they see how things work and they know they will lose their power, they will lose the next election if they don't go along with the powers that be, and they change.
We're going to open it up. There's some people here I recognize, Deana, their names. There's some amazing people here, some very educated and people that I would vote for in a heartbeat over any number of people in office in DC and other places.
Absolutely.
Thanks for hanging in with us, everybody. I'm so glad to see you. And Monica is here tonight. How are you? I haven't seen you in a little while.
Yes, great. Thank you. Same here. I haven't seen you. And I do have a question. Should I go ahead and start with my question?
Please.
Okay. Thank you, Deana, for everything you said. You said so much in such a short time at the beginning. I tried to take notes as much as I could. So as I'm going to ask my question, please correct me if I'm wrong in some things that I thought I understood. You were talking about how the legislators delegated authority, kind of washing their hands because they didn't want to get thrown off voted out of their position. So they kind of delegated the authority to lower entities that were not elected. And they went on and started enforcing the mandates on all of us. And you also talked about having to have a live case in federal court in case you were affected by this. And for example, you were fired from your job. And if you had a case that didn't go well, I imagine, in court, then you are able to pursue some claims in a new way, in a different way. Is that what I heard?
Not exactly. A couple of things. First of all, the legislatures did not start delegating authority because of the pandemic. The authority was delegated in the past, and that's when we're talking about these wayward, lower level people, these unelected officials, agencies, whatever, trying to grab onto a clause and saying, "Look, we have power to do this," because the delegations came many years ago, and I think this law that we talked about today was passed in the 40s or something like that. So that's the first step. The second thing is when it comes to, you say, if they challenge in court and they lose. Okay, once you challenge in a court, any claims that could have been brought in that lawsuit, even if they were not brought, you will not be able to litigate later. It's called res judicata. Once you have litigated claims, it's over. So you can appeal a bad decision. But if you fail to state certain claims, you fail to bring claims that could have and should have been brought, you're precluded later from bringing those claims. So, and of course, the claim you brought and that you lost, you're done unless you can win in the Court of Appeal. So you can't bring another lawsuit. There's always some exception out there, but in general, once you challenge a law in any court and get a final decision, you are precluded from challenging that same law again in another court. But someone else can. The same plaintiff cannot. But that's why I'm saying some of these healthcare workers, in my opinion, should be hopping to it and filing another challenge to the healthcare worker mandate, this time under the Liberty Clause. But they haven't done so yet. People think they're going to lose. That's what they keep saying. And I keep saying that, look at the law, read Jacobson versus Massachusetts. I disagree. But I'm working on that now. And I've been told that I'm going to be retained by a powerful political figure and an existing client to help bring a Liberty Clause challenge. So I'm, I just got in yesterday. I've got jet lag, but I'm hoping in the next few days to sort of recalibrate and start working on that, because we need to do that. And as long as the medical evidence is sufficient, and we do have expert witnesses already lined up, doctors, to talk about the lack of efficacy of this so-called vaccine, which isn't a vaccine at all. Pfizer and Moderna are gene therapies, are not vaccines. The SEC filings, the Securities and Exchange Commission filings do not call them a vaccine. I think I saw Pfizer's, one of them, they call them gene therapy. They didn't start calling them a vaccine until they were marketing them, because they wanted to hone in and take the goodwill our people associate with vaccines, because historically vaccines were a different thing. They were a partially disabled antigen of the disease to give the body a chance to create immunity without the full-on attack. This is totally different. This is gene therapy. Moderna and Pfizer go into your body, these gene therapies, and they tell your body to create the spike protein from COVID-19, and your body is now producing the toxin, trillions. And then your body is going to react to it. But that's a very different mechanism than a true vaccine. They should never have been allowed to be called vaccines at all. But the CDC changed the definition of vaccine in August of 2021 to allow them to be called vaccines. And most people don't know that. Most people weren't even told before they took Pfizer and Moderna. It's not a vaccine at all.
Yes.
Lack of informed consent.
How's that, Monica?
Pretty good. So we're talking about basically fighting in court with attorneys and doing a lawsuit within the statutory law, right? We're not talking about common law.
Well, common law, then what could people do to stop these mandates? If people would just not, would not adhere to them, would reject them, resist them, and oppose them, and what's going to happen if all our military men and women say, sorry, I'm not taking the vaccine? My son did. My son's getting fired. But he's an Army sergeant. Imagine if all the military men and women would say, nope, not going to do it. We would win. We can't go without having a military. You see, if people would stick together, that's why we have unions. Watch Norma Ray. What happens when people stick together as common people? If we would stick together and stand together and not be such cowards, we could win this. But too many people are like, oh, I got to pay my mortgage. I got to pay this. They don't have any faith. The lack of faith in our society, the lack of religion, goes hand in hand with what's happening.
I get it. And so in my case, I was fired, and we were 3 interpreters in Los Angeles Superior Court that were fired because we did not want to give them the authority to decide whether we get exemptions or not, because we didn't believe that they had any authority in the first place. So we were fired. Other people had chosen to do the exemption route. So we went and did an ex parte petition for an emergency injunctive relief in common law. And of course, it didn't take long for the judge to just close the record and run out the door. She was quite upset.
I mean, unfortunately, California is one of the most corrupt states. A lot of my friends believe Seattle is the most corrupt city in the country. A lot of my friends who know what's going on in Seattle is an absolute disaster. LA's slightly better. Hawaii is gone. Hawaii is just, oh, good Lord. I mean, it's terrible there. A lot of people won't go to Hawaii, including me. I will not go to Hawaii anymore. So, you're in, unfortunately, one of the worst jurisdictions. If you were in Texas, the courts would probably support you. The governor certainly supports us on this. So you'd be better off in your job in Texas, but in general, you're probably better off in LA. So, but that's why you lost. You're in LA. A lot of it's political at this point.
Right. The person we made personally responsible was the CEO of the Los Angeles Superior Court, which I found out yesterday is now resigning from her position. I don't know what motivated her to do that, but anyways, because we weren't denied, I was wondering if, from everything you have said, if there is any recourse that you can think of. Just a note there that I didn't expect this to happen during the hearing. The courts, this CEO apparently used her own authority within the courts to have the courts notify her of when my hearing was going to happen, because I did not notify the other party. I was acting under common law, not under statutory law. So I did not do any proof of service to the other person and had no proof of service, but then they showed up. Meaning they found out from within the court. So there's so much corruption right there. And I have the transcript, but anyways, What would you say to people like us, huh?
Two things come to mind. The first thing is you sue the individual who's responsible for promulgating the mandate. I don't know if that's a CEO or not. I don't know enough about your system, but you want to make sure and sue the person responsible for signing the order or whatever it is. And I don't know who that person is. So that could be a problem. I don't know the answer because I don't know who this, I don't know if that is, was the CEO the person who passed the mandate or not?
Yes, she was the one to decide to do it.
That's what the second problem. The second problem is you're working within a judicial system. We can talk about how corrupt it is and whatnot. But if you're talking about challenging something within the judicial system, you've got to use the judicial processes. You've got to create, you have to do everything by the book. So even if it's we the people, even if you're relying on the 9th and 10th Amendments, I would still follow all the procedural rules in court. Otherwise, you're going to get bounced out because the other side has their rights too. And they have a right to due process, meaning notice and opportunities created.
She gave them notice and opportunity. That's the question.
Well, it sounds like they did, even though they may not have been the typical way. It sounds like if they showed up in court, obviously they had notice, right? So they waive that if they show up. Usually, if they come to court, answer a pleading, whatever, they waived effective service normally. So you should be okay there. But again, I don't know these particular rules in your jurisdiction.
Thank you so much. That's all I had to ask. Thank you. Thank you, Deana.
Move to Texas for sure. We lots of interpreters too here in Texas. Yeah.
Yes, thanks, Deana, for answering these questions. All right, Jason.
Hello, I was curious if she could make a, thank you for all your work and all your help and everything. Regarding the pandemic treaty coming up for the WHO, how would that affect the Supreme Court decision? Would it override it? Would it, like I've read some things about the idea that if they, United States joins the treaty that the WHO is putting together for the pandemic, then it would basically override the Constitution and the Supreme Court because it would be like an international treaty and international law.
No, not in this country. The United States Constitution is the supreme law of the land in the United States. Our courts, our government has failed to adhere to treaty provisions that we have signed onto and adopted right and left. We violate treaties all the time. We adhere when we want to, and we never, certain ones we never even signed on the Convention for the Rights of the Child, which every country in the world signed on to except for us in Somalia. So treaties are not, unfortunately, considered the supreme law of the land. Doesn't matter if it's international. It's one of the things people laugh about, with the international courts, or the Hague, and people laugh. It doesn't, good luck. United Nations proceedings, good luck. The supreme law of the land, here's the Constitution. The courts are going to say that. They're going to interpret the Constitution. That's it. So you can argue, though, treaties. You can always argue. And you can argue that because when our Constitution is interpreted, I wrote an article years ago called Elements of Liberty. Elements of Liberty is in the SMU Law Review in 2008. It talks about how our court interprets liberty. One thing our court does look at is international treaties, international laws, and trends in state laws. So yes, international law does affect our constitutional interpretation, but it will never trump our country's, our Supreme Court's ultimate say in what our Constitution means. So I didn't even know about this thing you're talking about. I wasn't even aware of it. But I can't imagine our Supreme Court ever giving up that kind of power. Remember, they're the final arbiters. They're the final rule makers. Those 9 people, why would they say, okay, this international treaty governs us now. We have to do whatever they say. I can't imagine that. So I don't know.
The text in the Constitution, I just looked it up. The text, I remembered it said something about treaties. It says the president shall have power by and with the advice and consent of the Senate to make treaties, provided 2/3 of the Senate present concur.
But once that treaty is made, do we stick to them? What impact does that have on our Constitution? And my point is simply that in the cases and the way our Constitution is interpreted, our Constitution is the final say. If there was an international treaty signed, let's say by our president and confirmed by the Senate, and it conflicted with our Constitution is going to win out. That's my opinion. I've never seen anything otherwise. And over again, our 9 justices have said the Constitution is the final say in this country. So they'd be giving up power. They'd be giving up so much power to say they had to do something. Because remember, right now, they're the interpreters of the Constitution. They're the enforcers. And as long as our Constitution is the supreme law of the land, they're the final say. Just 9 people. And it's often one person.
Well,
in those 5 to 4 decisions, it's one person deciding.
but then we're in the position of waiting 20 months again for somebody to
Yeah,
finally succeed.
sometime. But
The
that's
damage
what
has
we
already
have to
been done.
resist.
That's the worst could happen, huh? Is that we have to live under it until it gets to the Supreme Court.
Right, and it makes me feel really bad because I was older, I'm older, and so I was able to stay home a lot and avoid all these and I'm not gonna travel to Europe, I can wait. I'm not going anywhere, someone's gonna get a vaccine, but what about other people? What about school teachers who need both their income to support their children and they can't just both quit their jobs? I mean, this is what really makes me feel bad about our people is a lot of them had to make choices they didn't want to make. That's called coercion, that's called oppression. And they're using the vaccine mandates and the mask mandates to sort of test the limits of what they can do, what they can make us do, and whether we're going to stand up together and resist, or whether we're going to be like sheep and just jump off a bridge because the first one did. So they're testing us right now, not just with the vaccines, they're testing our will as a people.
Yes.
Time to be strong.
All right. Thank you, Jason. Anything else?
Nope, thank you.
All right. Let's see. Monique, welcome.
Hi, it's been a while since I've been here. Thank you.
Yes. Good to see you.
Good to see you too. Thank you for speaking today. You are so intelligent on this issue. I have two jobs. I'm a guest teacher in a large school district. I'm also an actor. I'm not exactly sure if I'm allowed to say who I work for, so maybe you can guess. But my
Okay.
yeah, I really don't know. I would love to tell you, but Leslie Manukian is involved with the district, if that gives a hint. Okay, so I actually mentioned this before, but I'm gonna use it as a kind of a different question. So there was a situation where I privately told a parent that when she brought up the pandemic, I said that it was planned. She called the district. I was off the job for 3 weeks because of that. Now, my question is, as an educator, aren't you able to state, especially if you're trying to educate from historical and just a compassionate level? I didn't say it to a child, but what are my rights for my freedom of speech and as an educator?
Okay, this is what's really interesting. First, there's two answers to your question. One, a body of law has been developing over the past, I'd say 10 years in particular, where public employees are told they cannot say bad things about their employer or they can be fired. Okay, that is so foreign to me. That's just not the way it's supposed to be. People, I'd say, in the prosecutor's office who know the prosecutor is doing something wrong, and that's an elected official. They've been fired in LA for telling the truth about what's going on, or for giving their opinion about how the prosecutor thwarted the case or thwarted justice. That's a real problem. I remember talking to Erwin Chemerinsky about that a while back. So that's been, a lot of things have been in play. A lot of sort of, evil forces have kind of come together. So you should have First Amendment rights, absolutely. But like I said, they're already trying to chip away at them by saying you can't criticize your own employer, even though your employer is a government. So that's been kind of surprising to me, that body of law, watching it develop and saying, this is horrible. If the people on the inside don't tell us what they're doing behind the scenes that are wrong, how will we ever know? Who will ever have that information and be able to share it with us? The second thing is, what they've done in this situation is they're characterizing free speech as misinformation. They're characterizing free speech as dangerous. Now remember, dangerous speech is protected. Pornography is protected. Subversive speech is protected. But there's a point at which the government will say that at some point it becomes, terrorism, or it becomes treason. So they're making these outlandish claims. I remember at one point talking to some people about some of our leaders, like Bobby Kennedy, being possibly threatened with being prosecuted for treason. Now, it was sort of a speculative thing because people were talking about how the government was starting to throw out these ideas that we're going to go after some of these people for treason. I mean, treason, are you kidding me? That's selling secrets to the other side during a war. That's treason. This is free speech, but they're recharacterizing free speech as something else so that it can be punished. And do I think you have a free speech right to say what you said? Absolutely, especially if you watch Plandemic. And
Well, attorney, I've been in this since like February of 2020. I watched all the documentaries and I know for a fact that it was planned. I mean, even Reiner Fuelmake has emailed me back a couple times. I tried to get him to speak at my teachers union. So, I mean, I didn't say how it was planned. I said she should look up Reiner Fuelmake. She could do her research. I've spoken to the Board of Education. I said nothing about how the district was involved. I just said it was planned. So I guess you could say that's my opinion, but with what Reiner did, oh, it's factual. But you know, what you were saying, Event 201 made it very clear that any disinformation, you know, would be taken off the internet. I mean, they did that back in October 2019. So yeah, but thank you for telling me. The other thing I have to ask you are the unions. So for, well, I could say Screen Actors Guild, you know, they won't let people work unless you have the vaccine. And, you know, they say you could get a religious or medical exemption, but the casting directors, they're not going to put you in place and then, oh, you try to get an exemption. That's not reality. So, and then as far as the union, the teachers union, they're totally behind the vaccine. And a lot of the teachers actually love it. So, I mean, what can you do when these unions are pushing it and it doesn't seem like any attorneys want to get involved? Because I'm sorry, you can't do that as an individual. You're too insignificant.
As my colleague Todd Callender keeps saying, we're in a spiritual war. Hollywood is filthy dirty. Hollywood has some of the worst human beings in the world in it. Hollywood is a conduit for mass media. Hollywood controls how we think to a large degree by the garbage they put on TV. I mean, these garbage sitcoms, I don't even know who's watching this stuff.
I agree with you.
But the thing is, turn your back on Hollywood. Turn your back on evil. Hollywood is so, so dark. Read my book about, my second book is called The Godfathers of Sex Abuse, Book 2, Harvey Weinstein, Bill Cosby, and the Me Too movement. Read how people treated Harvey Weinstein, how he treated people, how many people enabled him. Top actors, wealthy actors, they could have turned their back on him. Instead, they turned their back on all of society and all those women, and other women helped him. Hollywood is filthy. I wouldn't want to go to a Hollywood party personally. Because if you read the Bible and you read Buddhism, which I have, most religious concepts are stay away from those people. Bad energy. Cross the street. If you see evil coming, cross the street. Buddhism says their energy will infect you. I don't know why anyone would want to be in Hollywood. Well, actually, I do. They're lost, in my opinion. They want fame. They want fortune. They want to be looked at. Boy, oh boy, I don't know what happened in their childhood. Someone didn't get enough hugs, is what I would say. But I know I enjoy a lot of our actors. I'm a fan of some, Pierce Brosnan, I'm a fan of. I like Rose McGowan for what she did. She's strong. But I'm saying, unfortunately, a lot of us are having to regroup, restructure our lives, figure out how do we make a living? How do we move on? And how do we stay in the light? Because so many of our big institutions are just in darkness. And I think Hollywood is about as dark as it gets. Watch The Secrets of Playboy. It's on A&E now. And even though Hugh Hefner wasn't exactly in Hollywood, he was associated with Hollywood. And a lot of those girls were trying to get into films and whatnot. And a lot of the men from Hollywood, rich, wealthy actors, were part of, the social life at the mansion. There was tons of rape going on there, quaaludes, all sorts of stuff. I mean, it's even worse than I thought. I was invited to go to Playboy Mansion, 30 some years ago when I was a young lawyer in Beverly Hills. But, and I suspect I would have been stopped at the door had I wanted to go. Someone would have figured out who I am and said, oh, hell no, not that one. She's not going to put up with it. And she might turn around and sue somebody for sexual harassment. I mean, people know who I am enough. I was at a big firm in Beverly Hills at the time. So I know that it's seductive, girls who aren't that smart. They're not lawyers. They don't have something to fall back on. They're pretty though. they're pretty, they have good figures, and they think, okay, this is a doorway to get in to become someone like Marilyn Monroe, right? Or someone like Pamela Anderson, who you know, they got their starts in Playboy, they got big from Playboy. So there's those two examples, you know, Marilyn Monroe and I don't know, Pamela Anderson, and everyone else I know, their career was destroyed. Julie McCullough's career was destroyed through doing Playboy, because I was in a movie once with her. I just invited, I was just a Miss Mexico City in the movie once. And I know that after she was discovered to have done Playboy, she lost her job on this fabulous sitcom that she was on. She's so talented. Big mistake for most women. So watch that to get, you know, and I would say, unless you can find a segment within Hollywood that has funding to do some independent films or something like that, I would say find another industry part of it, because Hollywood is not where it's at. Those people are powerless. They think they're powerful, but they're not, because real power is coming out now. People are really finding out there are forces in this world that are not going to allow this to continue. And whatever you want to call those forces, God, nature, Mother Nature, that people call it different things, but there's massive restructuring going on in terms of power right now. And people who have a lot of money think they're really powerful. People who are famous think they're really powerful. But I think things are changing. I think we all need to stay with the light and go toward the light, because it's really, really, really dangerous times we're in my opinion. So I would say just stay away, you know, find a nice place where you can work. And, you know, I have some friends who want to start doing some documentaries. Let's see if we can find the funding. But there are people out there trying to change things. Look at the people who made Pandemic. You know, you might have been able to be an actress in something like that. So look for those opportunities. But I frankly wouldn't set my foot in Hollywood at this time. I wouldn't want to be around most people.
There you go. That's it, Monique. That's the answer. I know a lot of people don't like to hear that, and that's not just in your field, in many fields these days.
No.
Thanks for coming. I really appreciate it, and thanks for
Years
bearing
ago.
your soul with
Thank
us.
you.
It's really important.
Thank you. Thank you.
Really important to hear your voice. Thank you. Okay, Jackie, how are you? Wonderful to
I'm
see
fine.
you.
How are you?
Great.
Good. So my situation, I finally get to serve the other party. I had to do an amended claim. Remember, I started out with the ex parte, and I went ahead and said I'm going to go for a claim. So I've been doing that. So my thing is, I'm in federal court, and I have to file a summons to the wrongdoers, the other people, and I'm a little discouraged.
It is hard. It is discouraging. Not only are, you know, courts getting it wrong, or the attorney's not filing the right papers. I just experienced a situation where, you know, a case I was involved in was so strong on our side that the judge started just throwing the case. I mean, just, you know, not letting in evidence we needed, things like that. So there's a lot of problems in the courts. Now, if you get good help, you can still win. I mean, it depends on what court you're in. It depends on the judge. So I don't want to discourage you, but I don't know much about your case. So I don't know how to advise you, but I would say, you know, take a look at some of the civil rights clinics in the law school, see if you can get some free help there. I'm not sure if Berkeley has one or not at this time, but I know there's some schools that do have civil rights clinics. Take a look at that, a way to get, you know, relatively high quality help from, you know, law school, if they'll do it. Because a lot of law schools are, you know, part of education, and they're doing the same thing other groups are doing in terms of following these vaccine mandates and whatnot. So it's hard to get someone on your side from the academic world. But if you have a particular question about your case, do you want to send me an email at counterspeechusa@gmail.com? And
Sure.
counter speech is just like it sounds, counter then speech, USA at gmail.com. It's one word. And
Okay.
there I can give you more specific. I'm not sure this is the right place for it, because we only have a few more minutes, but I would like to help you if I can.
Yeah. Just like Monica, same situation, but I work at a school district. I am a healthcare, I'm a nurse, but I didn't stipulate all that I'm not fighting as a nurse. I'm just fighting because I stood up for my rights. Other people chose not to stand up. So I ended up standing up by myself. So I'm
Right.
fighting this. I feel strong about it because I did they served notice and opportunity, gave them all that with the did an affidavit, you know, the steps, they're the steps that I should have done. And I'm filing that, but I'm also filing civil rights violations. Breach of contract. I got precluded from working a day before everybody else was supposed to. I had a contract for that whole year, and the head HR guy is the one who precluded me. So I didn't get to finish out my contract. So
I'm sorry, it's happening all over the place, and they're justifying it from this whole COVID thing and this idea that the vaccines are going to help, and I don't think they're going to help anyway. So anyway, but yeah, do feel free to reach out to me.
thank you. I appreciate you though,
Feel free to
really
reach
do.
out, Jackie. Okay.
Thanks, Jackie. Portia.
Hi, good evening. Thank you so much, Dana. This has been very informative and very enlightening. One thing that I observe with, what's going on here, the majority, and I know a lot of people use the word democracy. I'm not fond of democracy, quite frankly, because of where being a democracy that the so-called majority is forcing these upon us. Or perhaps it's the minority and it's just that they have a lot of power and control. But nevertheless, I feel that the difference, and a great difference right now in what's happening in our Constitution, in our government is, we're no longer the republic which the country was found under, where the republic, the Constitution protects the rights of all people from the will of the majority, as opposed to the rights can be overridden by the will of the majority under the democracy. So for those reasons, I like to think of us as the republic that we were originally founded on, and to operate from that place. So much of what's going on, and as you so poignantly said, Clint, this brave new world, it's just unbelievable. Some of the things that the courts are doing that is so blatantly against their oaths that they took. And Dana, you were so clever in mentioning the fact that they're considering what we're doing treason. It's just laughable, because everything they've done, this administration, is treason. They took an oath under the Constitution to protect us, the people. And everything they're doing is to destroy us and to destroy this great nation. So I have very, very little use for them. And I'm going to continue to go down the path of the Constitution, because that's the only leg we have to stand on. The framers of this great document, and I believe it's a living document, and they were inspired by the Creator, whom I call God. And that's who I stand on, not the government. But thank you so much for your enlightenment and your expertise as a bar attorney. No offense.
No offense. Thanks so much, Portia, for your comments. Thank you. Okay, Elka.
Thanks for calling on me. Thanks, Deanna. I'm not sure if somebody asked that question already. That case in Florida, what impact does it have on the hospitals and medical clinics right now? Because we are still here in Southern California asked to put masks on in order to see a doctor in a clinic.
Well, this particular case involves a mask mandate concerning I believe it's just travel, right? I mean, I don't think it has anything to do with anything.
Yeah, that was the mask mandate for travel.
This is the case talked about today. This has to do with a travel mandate for masks. We also talked about the OSHA case where the court struck down the mandate for all people who are working for an employer with 100 or more employees. We also talked about the vaccine mandate for healthcare workers, which was upheld by the Supreme Court. So here's what happens. This case is a federal court declaring the CDC's behavior ultra-virus. This is the rule of law as of right now, unless it's overturned on appeal. It's been declared basically ultra-virus. So what can happen? It's going to go to, I think it's the 11th Circuit in Florida, and they're going to either affirm or reverse. And then I'm going to venture to guess it's going to go to the US Supreme Court unless the US Supreme Court refuses to grant review. So does it affect us? Yeah, I mean, technically it certainly should. Anytime any lower federal court declares something unconstitutional or declares a law invalid as a matter of federal statutory interpretation or constitutional interpretation, that law is done until a court of appeal overturns it, if a court of appeal overturns it. So what this means is, as of right now, the mandate should not be in effect. But we're seeing so many strange and squirrely things these days. You know, we're seeing people just refuse to acknowledge a court order. So, and we're doing that too. We're the ones, refusing to acknowledge, that these vaccine mandates and the courts ordering them or declaring them constitutional, we're the ones rejecting that. So it kind of goes both ways. So I'm not quite sure how this will, I imagine that the losers here, you know, are going to file an appeal right away and try to get it overturned. But
They have, yeah, they're going to appeal.
should be effective until, that's the judiciary's role. See, that's the balance of powers, separation of powers. The judiciary's role is to be a check on the legislature. And that's why the judiciary is not elected. It's a non-majoritarian influence to control the other majoritarian branches. So the courts are the final say because they have to protect the discrete and insular minority classes against the majoritarian influence, because otherwise, whoever's in the majority will just say, we can do whatever we want, you know, and everyone else has to just deal with it. Well, we don't want that. That's tyranny by the majority. So the courts are the non-majoritarian branch, the unelected branch, and the branch with life tenure, so they can do what's right and not worry about being fired or not being reelected. So that's my answer. This is the final say for now. Or
Well, yeah, the strange things happening, of course, there's so many companies involved in terms of transportation, right? The airlines, there's some city buses, the municipal bus lines and things, but
and
Uber.
This is an area I'm not an expert in. I'm not really an expert in civil procedure. I've never taught civil procedure. I'm kind of going back to law school, remembering kind of what the deal is, but
I just wanted to say how it's actually playing out.
I mean, it's been declared.
Well, so how it's being played out is that the federal government is determined to appeal it, but then the CDC doubled down and said, even though this ruling happened, we still recommend it. It's okay. It's not an order.
I was on a flight.
But we still recommend it. So it gives all of these airlines, for example, or any entity in transportation that, like even the TSA potentially, to go ahead and continue to require masks.
Keep in mind.
Based on a recommendation now, because.
Well, let me speak to that. If it's a private entity, sure, they can do what they want. But TSA is government, isn't it? TSA is not private, is it? I'm not.
Well, some people say that it's all municipal corporations private, but it's supposedly a government agency.
Let's get away from TSA. Southwest Airlines, could they still require? Yes, they could, but I can tell you I flew yesterday from Houston to LA and they didn't require masks. So, of course, Southwest is kind of a cooler than average airline. I mean, that, you know, they had early on their employees balked at the mandate, and then Southwest backed down. Southwest is based right by Dallas, so it's a Texas corporation, and Texas has had more of a common sense view on this, I would say, than a lot of other states. So, you know, Texans were really not going to be told what to do with their bodies. You know, that's I mean, a lot of people feel that way in other parts, but I'm saying Texas has been one of the states, and the governor signed an order early on saying no person, you know, can be required to get a vaccine to stay in school or whatnot. And some of that I think was knocked out. But anyway, so to answer your question, this just should be enforceable against any government entity. And they can't just turn around and say, well, we have our own policy, because they would have to have delegated authority to pass a vaccine mandate. They just can't. If they call it a policy, it doesn't change the fact that it's state action. Okay, if they say, well, we have a vaccine mask policy here at, you know, Park Ranger Station 10. Okay, they don't get to do that. They're the government. So a public beach, you know, lifeguard can't just decide, well, I have a mask mandate on my beach, because they don't have the authority. So this should be, but expect this to continue going on though.
Yeah, so Elke, I would just have you research the Supreme Court blocks Biden's vaccine or test mandate for large private companies and healthcare workers. Okay. All right.
So, that case either. I'm believe me, I'm working all the time, and it's so hard to keep up on all that's going on.
Yeah, same here.
Yeah. So I don't know about that case, but I would imagine that. Well, first of all, the body that has always had healthcare policy rulemaking power are state legislatures, not federal. So, and certainly not the executive branch. So we're looking at a lot of squirrely stuff. I think it was actually Obama who's sort of credited with trying to expand the executive order power, because it wasn't really that litigated. And so there's a lot of parts of the Constitution that aren't that litigated. So that's when people like try to grab, you know, some body of law that hasn't been developed very well and try to kind of throw it in the wrong direction. So
they can get away with it for 20 months until they're held to account.
Well, that's the problem. But Biden shouldn't be yeah, Biden, though, he's a puppet. Biden is, you know, may very well go down as one of the worst presidents in history based on everything that's happening in our economy and based on how much the people are so against him right now. I don't know what his rate of approval is, but I think it's incredibly dismal. 26% or something like that. And those are the diehard, you know, liberals who will say that anyway, no matter what he does, you know, because they're diehard liberals. But there's been a lot of grabs for power among people who don't have it. And the people who do have it are cowards. The legislatures aren't passing laws prohibiting it. They're not passing laws demanding vaccines because they know that the people won't like that. So they're just kind of sitting there, you know, not doing their job as our representatives and letting all these other people fumble around and attempt to exercise powers they don't have. So
Okay, well, I just wanted to thank you so much. You're a bright light in my life. You're a breath of fresh air. You're an extreme valuable resource to everyone who was fortunate enough to come here tonight and be with you. I hope to be able to have more with you in the future. Please, yeah, I see applause, hearts here. We'll hang out a little bit longer after Deana goes.
And so nice to be able to talk to you all tonight. Thank you for listening. I'm here to serve and I'm here to help. So I hope that I can help you with more questions. If you have more questions, again, counterspeechusa@gmail.com. Feel free to ask me questions and I'll talk to you soon, Clint.
All right. Much love. Bye-bye. So what brought you out tonight, Lou? I'm just curious.
Oh, well, I've been following you. And of course, we were on the weekend, this past weekend, and it was very enlightening and informative. So thank you for reaching out to us and spreading that to us, because otherwise we wouldn't have known about it. And thank you for doing these sessions at night as well. We sure do appreciate that.
Absolutely. Yeah, you're speaking about the Private Society Solution Symposium that was just happened in San Diego this last weekend. It's been recorded, and if you stay close to your info@commonerlaw.com email, you'll get a message soon when it's published online, and you'll have a chance to listen to it, folks, or re-listen to it in the case of Lou. Yeah, a lot of great information. Particularly, I thought Saturday afternoon was amazing in terms of sound money and the technology that could help us decentralize and disintermediate is the word I like to use. It's my most precise way of calling it. But yeah, a lot of folks just want to, instead of fighting the powers that be or trying to restore the republic, which is definitely something I'm involved in a big way. There are some people who just want to break away, and actually it's perfectly lawful to create assemblies and associations, a free association based on free contracting with your fellows to create all numbers of clubs or associations allowing you to do the things that you want to do freely. A really great example is healers or healthcare providers. There's a lot of legislation that regulates physicians and doctors, and they feel strapped, and there's all these treatments that they'd like to be able to bring to their patients, cancer patients and any number of ailments. Well, guess what? If they break the rules, they lose their license. And well, I say, so what? We need to imagine a post-license world. But in the meantime, healers can create a private membership association so that they are no longer physicians and their patients are no longer patients. They're all members in a free association. And so all the legislation that regulates physicians and patients and all those things don't apply any longer. And it's really a very clever thing. You have to do it properly. That was kind of the spirit behind it. It was called the Private Society Solution Symposium. What did you think about it overall, Lou?
Oh, I thought it was amazing. There were so many great speakers and there was so much information shared. They did a very good job having their presentations down. And I just thought, and there was such variety. There was this whole variety of things, not just from the legal side, but also from a spiritual perspective and how it all ties together. I was very impressed with that. I thought their lineup of speakers and their lineup of information and how it was rolled out over the 2 days was excellent.
Yes, thank you. All right, Lou, good to hear your voice.
Yeah, baby. Good to hear yours too. And thanks again for, sharing all of this. One question I had for Deana is, what type of attorney is she? What's her?
She does do litigation, but for years she was a constitutional law professor at a university in Florida.
Aha.
So she focuses on constitutional law, yeah, and which is exactly what we need nowadays.
It surely is. It surely is. That's where we're really seeing so many people's rights being just abused dramatically. Their rights are being taken from them, and they're not being able to really know a place that they can get redress like we're supposed to have, right? And,
Exactly.
you know, it's so confusing, and you get smacked down by the judges, as they say, 3 times, 3 times until you win. But, you really got to have some guts to put up with that and be prepared for it. And I think people just being aware that they're going to be smacked down 3 times, so you're not upset about it when it does happen. And we've seen this so many times, and people just got to get with it and stick with it and really have the intestinal fortitude to know that there's another solution.
Yeah. Thank you for those wise words. We got to stick together too. The other thing to just really add to what you're saying, Lou, is that it's easier to go through it together. These smackdowns, these tribulations. Yes, Monique.
I wanted to see a ND a few months ago, and we had a great conversation. Then she wanted me to come in with the mask, and I was floored. Well, I found someone else, and she's like, "Oh, we make it optional." She didn't believe in it, but yeah, they've got into the NDs too, unfortunately.
Yeah, exactly. It's not just the mask. This has been going on for a while. The kind of overregulation of health solutions. It's a crime for many, many, many years. We need to liberate ourselves from that syndicate, that crime syndicate known as the healthcare industry.
Yeah. Thank you.
All right. Once again, everyone, beautiful to see you all. Sue-Ann.
When she talked about the case, and what the court said is they have to provide an emergency, that statement is also in Workington versus Soria, and Soria, and it's a federal case, and they said the same thing, and it had to do with property. So anytime they're claiming an emergency, they have to prove the emergency before they can utilize that. And that case is 2016, Workington versus Soria.
Okay. What does it conclude there?
Well, it has to do with property. And at one point they stated that they said they had the right to invade the property because it created a emergency, because children would want to get into the stuff on there and they would become harmed by it. And that particular court said the same thing. Okay. So you have to understand, the government cannot say there's an emergency without the proof of that emergency. And at no point have they ever been able to prove the virus.
Exactly.
Okay.
That, and we need to challenge them on that very thing right now. So yeah, we the people need to understand this emergency powers that states and federal governments claim to have, and exactly what grounds they use. And that would be something to empower us, the people, to be able to authentically and successfully fight it back. The government just can't declare an emergency. They have to actually prove it. And we can make them really prove it. Like you said, prove that there's a pandemic, prove that there's a virus. All right, Sue-Ann, thanks for showing up tonight, and thanks for your comments. We will see you next time.
Aloha.
Here's the golf course.
Aloha.
Thank you.
Aloha.
Happy Mother's Day weekend.
Yes.
Happy Mother's Day to all you mothers.
Come on, Clint.
out there.
Good night, everybody. Bye.
Good night.
Thanks, Clint. Bye.
Good night. Thanks.